Good morning, everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So the first thing I want to talk about is I want to give you more information on the changes that are coming up for international students. Last week we talked about a new rule that will greatly impact international students as well as members of the media. Same rule, but I just want to give you a little bit more information that is coming out of that rule. So as we know, international students, when this rule becomes effective, will no longer be issued I-94 cards that have D/S as their expiration date. Some people call it duration of stay, some people call it duration of status. It is D/S essentially means that there is no hard and fast date by which you must leave the US. And so this rule changes that. So there will be no more DS issued. It will be a specific date, just like many of the other non-immigrant statuses. So that date will, depending on your degree, will be capped at 4 years. Sort of, I guess, with the general thought that at least most undergraduate programs are sort of thought of to be 4-year programs. There are some 5-year programs, but most are generally around 4 years. So I'm assuming that's where they came up with the 4-year date. So if you want to extend your international student status beyond that 4 years, and it will be a specific date on your I-94 card, you will either have to file an extension of stay if you are in the US, or you can leave the US and do the same process all over again, just doing it at the US consulate overseas. So that brings the international students more in line with the other non-immigrant options. But what it does, when it does that, it puts the onus on young international students to really keep track of their expiration date and make sure that they are keeping track of their expiration date, making sure that they are staying in status, and also making sure that they're really keeping in touch with their foreign student designated officer at their school. So we will see how that works in practice. The other thing that this rule does is it changes the grace period after you graduate, after you do your STEM, your STEM OPT, after you do your regular OPT. Currently have 60 days. Right now, or with the new rule, you will have 30 days. So it is reducing the grace period from 60 days to 30 days. That is a very quick turnaround when we talk about sort of packing up your life after school and going back home if you do not have sort of a plan B by which you can lawfully remain in the US, change your status, and do all of the things. So no more DS in the new rule. The grace period goes from 60 days to 30 days. It is being reduced by half. And the I-94 cards, your status will be for 4 years at a time. So if you're in a 5-year program, or you want to go from, say, a bachelor's degree to a master's degree to a PhD program, or you want to extend and switch and go to a different program type, you will have to either file an extension of stay or go back home, apply for a new visa, and come back in. So those are some more changes coming out of this new rule that impact foreign students. The rule also, it's not limited to foreign students, it also impacts international media. So just keep that in mind as well. But today I just wanted to focus on the student changes for international students. The next thing I want to talk to you all about this morning are the visa processes on the continent of Africa. So visa processes will be realigned The State Department, who oversees all of the consulates outside of, all of the consulates and the embassies, we talked a little bit before, they have decided to create regional hubs on the continent. So not every consulate or embassy in a country will process visas, whether those are employment-based visas or family-based visas, or green card applications. So effective August 1st of this year, so in a couple of days, that realignment will become active. Those hubs will become active. So if you have an appointment that is already booked and it with a consulate, and you are not sure, if you've not heard anything thus far and your appointment is from August 1st onward, monitor your email very closely. They have said that they will, in fact, be sending folks emails. I imagine those emails will come in waves. So I'm imagining the folks that have interviews, closer to August 1 will get their emails first. Further away from August 1 will get their emails second, third, fourth, and fifth. Just my guess, but that would make sort of the most operational sense as they look through what they have to do in order to get those changed. And they will also inform you of where your new interview will be, if it will in fact be moved. And impacted case types are kind of almost all of them based on sort of the broad language within the announcement. So it is family-based cases, employment-based cases, K-1 fiancé visas, diversity visa, follow to join for refugees, asylee visa. So very large, broad brushstrokes of which types of cases will be impacted. So that said, the visa processing is moving to a hub system. The embassies and the consulates themselves, if they will no longer be processing visas, those consulates and embassies are not closing. Those consulates and embassies will remain open. They will do everything else that they usually do. So it'll be business as usual in those offices, except for the visa applications. So consulates are not en masse closing. It is just the sort of alignment and consolidation of the visa process itself. So I want to make that very clear. I don't want anybody calling me saying, Carol said that consulates were closing across the continent. Consulates and embassies are not closing. It's just the type of work that they do. So last on my list of things to let you know about this morning is the H-1B $100,000 fee is gone again. So very short summary of what has happened with this. The court ruled, or a federal court judge ruled, that the $100,000 fee was impermissible. The government decided that it was going to appeal that decision and essentially said to the judge, hey, we'd like to keep this fee in place because we're pretty sure that we're going to win on appeal. And if we do, and when we win on appeal, having to go back and collect that $100,000 for those folks that were approved during that, sort of during that interim period, it's just going to be really hard and it's going to be really onerous on us. So the judge said, okay, I'll let you leave the fee in place. So then the fee was left in place, even though the judge had ruled that the fee was actually impermissible. But the judge then didn't want this case to sort of languish, right? So now a federal court judge has denied the government request to keep the fee in place while the case sort of winds its way through the court system. So that said, as of right now, the $100,000 H-1B fee is no longer in place. I fully expect there to be more on this in the court system. So I will keep you posted on what that more looks like. But for right now, there is no $100,000 fee. We'll kind of see how long that lasts. And we'll see how that is or is not implemented by the government. based on what happens in federal court. So if you have any questions about that in terms of a very individual case in your own fact patterns and your own situations, we're more than happy to kind of, sort of chat with you, walk you through what's happened in the past, what we think may happen, the timing, all of the things. So that is what I have for you this beautiful Monday morning. Have a wonderful Monday morning. Have a great rest of your week. I will be back next Monday with more updates. Bye.